thank you for zooming in today with us. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, The Legal Brief with Barriston Law. Thank you to all of our community partners for supporting with the sharing of our events. And of course, a big thank you to our sponsor, Barriston Law, for delivering today's session. So without further ado, let's get started. Chris, I'll hand it over to you.
So I want to start out really getting down to what a trademark is. So there's three main types of intellectual property law: copyright, trademarks, and patents. They all overlap a little bit, but are all distinct and have their own unique nuances. So copyright is a trademark in any work of art, which is a very broad term. You know, it can be a novel, a painting, a photograph, and that arises just by virtue of creating that work of art. So there is a registry of copyright, but copyright comes into existence just, by putting pen on paper or typing on your computer. That's what creates the copyright. A patent, on the other hand, is a novel invention. They only come into effect by filing for a patent, and that is a lot more complicated and, generally involves engineers, and a lot of the lawyers who do that work are also engineers or scientists, because, it's not what your average business would deal with. It's a lot more complicated, and mostly deals with scientific inventions. So trademarks, they represent, essentially they're used to distinguish the provider of a good or service. So the law has always recognized, since way back in the common law, that we need to protect the goodwill that a business creates. So when McDonald's sells a Big Mac, that M on the box has some intangible value to the business that someone else selling the exact same hamburger won't have the same, value proposition to its customers, because they don't have that M on it. So this goodwill that's created by that trademark, so in McDonald's case, their golden arches, is protected by law no matter what. So there are both registered and unregistered trademarks. If you don't register your trademark, you're limited solely to the remedy of what's called passing off. And this means some other individual has tried to market their products and pass it off as though they're yours. So say someone else sells a hamburger with a yellow M on it, and it's slightly different, but to the average consumer, they would think, yep, this is a McDonald's hamburger. Then McDonald's would be able to sue them for the tort. Say they didn't have their trademarks registered, they'd be able to sue them for the tort of passing off and say, you've fraudulently claimed your products are mine, and therefore I'm going to sue you. It's not a great defense, because you have to prove that they actually knew what they were infringing, and that the whole point of them creating their product was to base it off this other provider's product. So that's not a great remedy. So that's why we've created what are called registered trademarks, and that's what most people think. When you see the little R with a circle around it, that means the trademark's registered. So the whole point of these registered trademarks, it essentially is like if an old blacksmith would have, implanted their little symbol on their swords or their knives or whatever they're making. That's the idea of a trademark. And the registered trademarks protect federally your mark, whether it's a name, logo, across all of Canada. And once you've registered, then no one else in Canada can use that mark for whatever goods and services you protected. So the process for registering a trademark, I'll go through with goods and services that are protected later, but I want to give a bit better idea of how you actually get to registering these marks. The first thing you're going to want to do is do an availability search. And this is essentially the person looking at the trademark database and doing an in-depth search in Ottawa, saying what other trademarks are out there that could potentially confuse a customer or a potential client with the mark that I'm proposing to register. So say, I'll use McDonald's since I've been using that. Say there's a new business, somehow they've never heard of McDonald's, they're called McDonald's with an MAC, and they want to register McDonald's for their hamburger chain. They'll do the search, they'll see that McDonald's is registered, and then a prudent either lawyer or trademark agent would look at that and say, this is confusing. Anyone else, even though they're different trademarks, one's Mick, one's Mac, any average consumer looking at this would be confused and think your goods are really the goods of this other provider. They registered first, so this will probably be rejected by the trademark examiner. And that idea of confusing goes throughout trademarks, because it's not just identical matches that are prohibited, it's anything that would be confusingly similar. And that test is just based on your average consumer. So someone walking through the grocery store sees two products. If they would think they're from the same source, then they're confusing, and whoever registered first gets priority. So assuming after that initial search, everything looks good, you then file with the trademark office. So this can be done online, either through a trademark agent or just through the online portal. Essentially, you select the trademark you wish to file, and whether that's a series of words or a picture. And with some new amendments that I'll touch on later, that's expanded to smells, colors, sounds, flavors. And there's some interesting rules around that, but I'll touch on that later. And then you also select which goods and services it will cover. So you're only protected with your trademark for the goods and services you register with. Before, this wasn't that big of an issue because there was no additional cost for the numbers of goods and services. So you create, a big laundry list of everything you could possibly ever use your trademark for. You submit it and you pay your filing fee, which I believe before the amendment was about $250. And then you're protected for everything you've listed on there. There's also this concept of use, that you're really only protected for what you're actually using the trademark on. So say you sell computers, but you've also covered clothing because you want to use your logo on apparel, or TVs. If you don't actually do that, you can't protect it. You can't just sit on a trademark and essentially be a trademark troll covering a bunch of areas that you don't actually intend to use. You only get what you use. But with the way the new system works, you have to pay for each class that you file under. So there's 45 classes, I believe, 34 for goods, 11 for services. And now when you file, you pay $330 for your first class, and then $100 for each class beyond that. So clearly, if you want to cover all the classes like people used to do, that's no longer going to cost you $250. That'll now be in the high $4,000 range to file that application. The idea behind this is to deter the trademark trolls from, picking a somewhat common name that hasn't been trademarked and covering everything, and then essentially extorting potential businesses when they want to use that similar name, saying, sure, I'll trade it to you, but you have to pay me, $100,000, $10,000, whatever they think they can get from this business. And so those classes, they're called niche classifications from something in France. They were created out of a French law. Basically, they're a universal worldwide standard for classifying trademarks. The reason for this is over the past 5 years or so, countries have been moving to a more universal standard that all trademarks throughout, people who have signed the Madrid Protocol, they all use the same filing system, the same class system. This allows you, if you have a product in Canada, to create an easier filing process if you want to operate in the UK, the US, Europe. Before, every country had a very different system, and it wasn't universal. This process in this country, this process in that country. You need to get lawyers and trademark agents in each separate jurisdiction. Whereas now you can file in Canada using the Madrid Protocol, in hundreds of countries. So it's a lot easier for business owners, especially because now even a small business, if they're selling goods online, can have a presence across the world. You're no longer limited to your immediate jurisdiction, and separating trademarks based on country is a bit of an artificial delineation that doesn't accord with how the world works now. We're more, international, and trademark law has moved to represent that. And as of a year ago, in June 2019, Canada's laws have changed to go with that Madrid Protocol and allow for filings across the world. So once you've filed, you think, okay, I'm done, I filed, I should get a response back soon. Sadly, it's not that easy. The trademark office right now takes about between 18 months to 2 years to actually get a response back to you of whether your trademark meets the basic form requirements, if they think there's a competing mark. So you're stuck in limbo for about 2 years waiting for just a basic response from the trademark office. It seems like they're taking steps to try to streamline this, but we haven't seen any fruits of that yet, and it's still very slow. The good thing is, though, is once you file, the date of your trademark is based on when you filed. So even if it takes 2 to 3 years to actually get the registered trademark, if someone comes in after 1 year starts using your trademark, you'll have protection over that because it's the first to file is when you get the rights over the trademark. Once the trademark office is good with it, you advertise. And this is a 90-day period where they publish the trademark and allow for objections. So say you filed your trademark for X, and then another business owner, has a lawyer checking these advertisements to make sure that nothing infringes on their trademark, and they see, our product's X, we've been using it for 30 years. You filed it, you've only claimed you've been using it for a couple. Someone can then oppose your trademark during this advertising period, and then you get into a fight of some sort, whether it's a couple letters and you come to an agreement, or it goes to court. And then hopefully nothing happens during that advertising period. And then at the end of the 90 days, you can register the trademark, and then you have rights over all of Canada for that specific mark. For a period of 10 years, it was 15, but with these new amendments, it's been shortened down to 10. And you have to renew that every 10 years with the Trademark Office. So that's the basic process for registering a trademark. The one thing to always note when you're registering a trademark is you only get what you register. So if you register one word, that's all you're going to get the trademark over. If you register a picture, you can't go change the picture slightly and expect that to be trademarked too. It's not a dynamic system. You only get what you've requested. So if you do go create a new logo, it's not going to somehow magically transfer from your old logo to your new logo. We're going to need to file a new trademark with the new logo and apply for the same goods, services, etc. So I think there was a few questions that popped up. I'll just look through here. So someone asked if a federally registered trademark in Canada protects you in other countries. It doesn't. It only applies to Canada, but there are some benefits to registering in Canada with other treaty countries. When you register the trademark in a treaty country, so someone who's using the Madrid Protocol, you then have 6 months. If someone files something in a different country after you've already got your trademark in Canada, you have up to 6 months to basically create a priority filing. So even though the other person has filed, say, in the US before you, if you file within 6 months, you can say, I filed in Canada. I use this mark in Canada. I'm entitled to use it in the States, not this other person. And that is a way that filing in Canada will help you in other jurisdictions, but on its own, no, it does not protect you anywhere but Canada. The borders of Canada is the only place you get rights over that trademark. There is still a common law trademark, though, that will protect you, and you can use the claim of passing off if your mark's been made known in that other country. But like I said, it's a fairly weak right, so you would like to, if you are going to use it in other countries, you want to register in those countries. Someone asked, once you start the filing process, if you can use the indications. You can always put TM beside a trademark. That there's no rules around that. That just shows that you're intending to use it as a trademark. The R, it actually has to be registered. So you'd want to wait until the actual registrations come through before you start using the circle and the R. But if you use the TM, you can do that. You don't even have to file to do that. That just shows that you're indicating you intend to treat that logo or word as a trademark. So someone has asked, I recently learned that our new business name is in the same name as another company in the US who filed for a trademark in 2017. You're in different business industries. One's a technology, one's a product. Should I consider changing the name before launching it? So not necessarily. We need some more information to give you, a proper answer. But in a general sense, like I said, you're only covered for what you've submitted. So if you look at their filing, and if your products don't either match those products specifically or are confusing with them, so say someone says they just cover t-shirts and you're selling long sleeve t-shirts, you're in a bit of a risky situation there. If the two areas are completely different and their filing only indicates they're protecting whatever products they're selling, then no, there's not necessarily a concern there, particularly because it's in a different country and it's a different industry. So there seems to be minimal risk, but to get a proper answer, we need to look into that further. For choosing a stronger trademark, a lot of what would be considered a weaker trademark isn't allowed. So something that's merely descriptive. So if you're just saying, if you try to trademark fishing rods for fishing rods, that obviously won't be allowed. If it's just a geographic location, that won't be allowed. So you need to have a unique name anyways. The stronger trademarks are ones, that are more made up. So I know Google is somewhat of a word, but it's not used in common language, or wasn't used in common language before Google became a thing. So if you use, if the word's made up, that's generally the best way to go, because the chances of someone else having used your name in the past is less likely. If you use something that's more descriptive, like your location, and say you roast coffee and you're in Barrie, so if you're Barrie Coffee Roasters, that's not quite as strong, because anyone who's roasted coffee in Barrie would technically be a Barrie Coffee Roaster. So you want to create something that's more unique, and that's easier said than done. I know a lot of people try it and it's hard to do, but that's definitely the way to create a stronger trademark. There's another question here: how do I protect my trademark once it's been registered? The best way to do that is to, you can't check every day. You can't make sure that, Google every single day and go through the first 100 results to see what's there. But doing, trademark searches every so often to see, one, if anyone's tried to file something that looks like it competes with yours or is confusing with yours, that's good practice to do. And doing a Google search, seeing, is anyone using a trademark that is either identical to yours or confusingly similar? If that's the case, we generally send cease and desist letters. That shows you have a intent to enforce your trademark. You haven't just filed for it and then you don't care. You're actively pursuing defense of that. And it may come to litigation if need be, if someone's using it in a way that is unacceptable. Because if you don't enforce your mark, even though it's registered, it could become somewhat generic. And if it becomes generic, then it's hard to say, you should have a registered trademark over it. Like Kleenex is an example where, people will call everything Kleenex. It's no longer, it still is descriptive of a particular source of goods, but so many people use the word, it doesn't have much value to it for the business itself. It just simply means, tissues at this point. So actively searching for people using it, and it doesn't need to be a letter from a lawyer, just sending an email to someone saying, cease using this, it's my trademark, here's my filing. That's generally the best way to do it. And if they don't stop, then getting lawyers involved probably is recommended. There's the last question here is with respect to the World Intellectual Property Office and cross-border enforcement regimes. So I would pass that on to Graham. He's the agent. I don't think he's here yet. So I don't have an answer for you right now on that. I would have to look into that further. But if you do want further information on that, I'd be happy to discuss over email if need be. Okay, so now I'm going to touch on a bit more some of the new things that have come out with the recent amendments, because they're fairly interesting in the way they've changed Canada's trademark regime. And there's a lot of non-traditional marks in place now that wouldn't have been considered 20, 30 years ago, but now are being registered. These include things like sounds, tastes, and other things like this that, on first thought, it's hard to think how this would, or smells, like how this would be able to be trademarked. And the one big limit on these types of trademarks is they can't be purely utilitarian in that, you wouldn't be able to trademark the taste of an apple, because that's the reason, you eat the apple, because it tastes good. But you could trademark, I know some software companies with SD cards and things, they've put almost a poison flavor into them so that if a kid tries to eat them, they'll be disgusted and won't eat them. That's an example of something where the flavor of the product has nothing to do with the product itself. You don't need a flavor for it to be an SD card. But now to make their product unique, they've added this particular taste to the product. Another example is the smell of crayons. There's no reason, crayon smells have no bearing on the product themselves. They don't make it any better or worse, but they are unique to that particular manufacturer. Other examples of sounds would be Harley-Davidson's engine. and I think they've taken steps to trademark that. So there's a lot of interesting things where they're taking, sights, smells, sounds, and putting trademarks on them that, wouldn't have been acceptable before. So there's still a lot of questions on, what the exact parameters of this are. But yeah, it's interesting to see where it goes. So for more everyday trademarks, another thing you can specify with your trademark is a specific color. Generally, we don't recommend doing that because when you do specify a color, you're limited to that color. So like I was saying, McDonald's, their golden arches, they may want to trademark their golden arches in the yellow and red because that's McDonald's colors. When you see those colors, they evoke McDonald's. Same thing with a Coke can. The red of Coke is unique, and a red can looks like a Coke can. And if anyone else, provides a similar colored can, then there'd be a question: are they trying to pass their can of pop off as a Coke can? So unless you have something about your product where your color is so iconic, you need to do it. We generally recommend if you do trademark a logo, it's just in black and white. You don't actually claim any color. Other particular things in Canada is you can file a trademark in both English and French. That way you're not prejudiced. If you operate in both languages, you don't need to file two separate trademarks that are the same thing. The concept of use in Canada is also important, and this was a lot more important before the recent amendments. Before then, before you could actually get your trademark registered, you needed to file a declaration of use. And this says, yes, I have in fact used this trademark in the marketplace for my goods or services prior to this registration coming into force. This is no longer a requirement with the new Madrid Protocol filings or any filings in Canada after 2019. Basically, is you file it. There's no reason that you have to say you're using the trademark. You file it as long as it doesn't fail to meet any other form requirements, then it'll get registered. Use hasn't gone away though. It still is important. So if you're a trademark troll and you file for this trademark you never intend to use, and you sit on it, you haven't done anything with it, you've covered all 45 classes, so you're blocking anyone else from using a similar trademark. They can still bring an application to remove your trademark on the basis that it hasn't actually, hasn't actually been used in the marketplace. But while the higher costs now will deter trolls in some extent, the fact that you don't have to declare use in Canada creates a higher risk for the Canadian trademark market, that people may just do these filings because they no longer have to swear that they're using them. They can just simply pick the name, pick all the classes, submit the filing, and if they have the money to pay, then it'll go through, assuming, once again, no other trademarks are infringed and all the requirements are met. So that's really it on my summary of trademarks. That covers the basis. So if anyone has any specific questions on any specific products or any specific types of trademarks, I'm happy to answer those now.
Awesome. Yeah, if anybody has any other questions, please feel free to put them in the chat. I myself have a couple of questions, Chris. I know you mentioned about the wait for the process of to get the actual trademark itself. Has it always been that long, or is there a reason why all of a sudden it's been like that long of a wait? It's been,
From my understanding from Graham, I haven't been practicing long enough to really have seen the long-term effects of it. My understanding from Graham, it's just crept up to this point. It kind of slowly got backlogged as more and more people started trademarking, and it slowly built up. First it was 6 months, then a year, 18 months, and then there was a big push because of the new filing fees being per class. There was a big push of filings right before 2019 when the new amendments came into effect, of people trying to get all these applications in, so they only have to pay the flat fee filing rate as opposed to $4,500 to claim all of the different classes.
And what do you have any examples of what maybe consequences or any cases that you've dealt with in terms of people not following kind of the trademark guidelines and kind of taking over somebody else's, and any examples you could provide?
Like someone infringing someone else's trademark?
Yeah.
But yeah, so it happens.
Lawyer talk. That's why he's there, and that's why I'm not the lawyer.
So it happens all the time. It's constantly happening. It's not like a
Yeah.
uncommon thing. It happens every day. The first step is always just the cease and desist, saying, you know, the hope is always the person's just ignorant of it. They haven't checked. We send a letter. They say, oh, sorry, stop using it. You know, more often than not, it doesn't happen like that. That would be a perfect world, but we don't live in one.
Mm-hmm.
So, you know, there may be a couple letters back and forth on why it doesn't actually infringe the trademark. You know, we're a slightly different service. The name's slightly different, so it doesn't really confuse anyone.
Right.
So then there may be, you know, it could end up with a licensing agreement where we say, okay, you know, we're not going to stop you, but you have to pay us X dollars to use the trademark. There are some concerns with that, though, because if you license out your trademark too much, then there might be a question, is it actually distinctive anymore? Does it represent your products, or are you just, you know, using it as a cash grab, and really it's just indicative of this type of product in general? If that doesn't happen, then it has to go to court. I don't do litigation, but a lot of cases that we look at, when that happens, assuming the trademark has been infringed, there'll be an order, you know, any damages that the actual trademark holders incurred. So that could be, you know, a derogation of the quality of their products. If there's a bunch of ripoffs going out, you know, consumer faith in that brand may go down. It's hard to quantify that exactly, but, you know, lawyers try their best. There can be orders for destruction of all products. So say it's a good and they're, you know, using the confusing trademark on their goods, the court might order that they destroy all their goods, which, you know, could be costly. So there's a good reason to look before you start using a trademark, because, you know, if you have a bunch of products, you have a huge inventory, that could be hundreds of thousands of dollars you're out of pocket because you've had to destroy all these goods because they infringe someone else's trademark.
Absolutely. Angie has a good question here, and I was actually going to ask it. I mean, first, my question would have been for somebody who has no idea about the trademark process at all. Angie's asking, what is the cost for the availability search?
Yeah.
And
so
mine would have been, do you essentially, the cost in general, do you pay for essentially the lawyer to go through with that, or is the trademark processing a cost of its own? And then in addition to Angie's question.
Yeah, so generally in terms of fees total, we do a ballpark. It all depends. If it goes smoothly, you'll be on the lower end, but if the examiner writes back with comments and you're back and forth, the examiner modifying the application because say, we don't really like the way this is worded. There's this massive book that the examiners use, and they're very picky with exact terminology. So we sometimes try to get a bit creative and expand the scope of certain trademarks, and the examiners sometimes let it slide, sometimes don't like it. So there may be some letters back and forth, fine-tuning exactly what's covered. So the initial search it's an out-of-pocket expense for us. We don't conduct the search because it's done in Ottawa at the federal level, and it's around $700 plus HST. The whole process, start to finish. This does change now that filing fees are variable, but it's around, say you just do a basic trademark one class, it's around $3,000 plus HST in legal fees and the filing fee, etc. So it's once again, it's specific based on the file, but that's generally where you're looking if you were to hire a lawyer to do that here.
Cool.
We are working on getting that down because I know a lot of people would like help, and that's a project we're working on, so we're hoping to have something about that soon, but we're not quite there yet.
Awesome.